Okay.
Good evening.
T.S. Chaudhary.
जी सर, गुड इवनिंग सर. आपकी बुलंद आवाज हमने पहचान दिया.
जेपी सिंह साहब नमस्कार. T.S. चौधरी.
जी नमस्कार.
चौधरी साहब नमस्कार. कैसे हैं आप?
नमस्कार सर. इसीलिए तो हम आए कि कैसे हम उस टेबल पे बिठाएं और जिनमें विष भरा हुआ है उसको अमृत में ट्रांसफर करें. Thanks, Mr. JP Singh. It's a good suggestion. I accept it. Thanks a lot.
Thank you.
Let's start.
Prabha, Swami, we can start, I think.
Very well. Good evening and namaskar. I have great pleasure inviting you all to the International Virtual Mediation Summer School 2022, which is being hosted by Nivaran, Mediators of the Supreme Court of India. I am Prabha Swami, a practicing advocate in the Supreme Court of India and a mediator. I will be joined by Jayesh, who is also an advocate in the Supreme Court and a mediator as well. Nivaran has been conducting several webinars during these COVID times, which has been a great learning experience for all law practitioners and students, among others. The Summer School 2022 is an extension of the same initiative and of the efforts being undertaken by Nivaran. The topic for today is mediation advocacy. We have the pleasure of having with us today Mrs. Olusola Adegbonmire and Mr. J.P. Singh to address us on the topic. We extend a warm welcome to both of them.
Thank you.
Thank you.
Advocacy can be classified into legal advocacy and mediation advocacy. Legal advocacy pertains to litigation as an adversarial process. On the other hand, mediation is a facilitated negotiation which provides a platform of self-determination and enables parties to amicably settle disputes. Mediation advocacy is vital. Mediation advocacy is vital in facilitating parties to arrive at a settlement. It requires a different skill set which enables lawyers to represent and assist the parties in arriving at a settlement. Legal advocacy, being adversarial, only requires advocates to focus on the point of view of his or her client, whereas in mediation advocacy, the advocate must work towards arriving at a settlement which is mutually beneficial, and as such, advocates need to adjust their thinking and facilitative methods. In other words, mediation advocacy must encompass all points of view in a dispute. Lawyers must be trained in mediation advocacy so as to set aside their adversarial mindset while involved in mediation proceedings. Mediation advocacy helps advocates to assist parties in arriving at a solution that is acceptable to all parties and appears workable to the mediator as well. A settlement arrived at in mediation proceedings has the obvious benefit of taking into consideration the rights and aspirations of all parties. It has the further benefit of being cost and time efficient. Mediation advocacy helps advocates work with the mediator to achieve the best outcome. In this regard, such advocacy helps the advocate and his or her client engage with the mediator in the process of problem solving in a realistic manner, bearing in mind the long-term implication of an adversarial litigation. Hence, the mediation advocate partners with the mediator as a negotiator and not as a litigator. Mediated agreements give the party a greater degree of participation in decision-making and give them an opportunity to express and communicate their views to the other side as well as to the mediator. As such, the role of a mediation advocate is vital in arriving at such a settlement. As a mediation advocate, you generally try to work towards mutually beneficial agreements. Being skilled in mediation advocacy helps one to present one's client's position and interests in a non-adversarial way and being aware of the mediation process. The role of an advocate in a mediation is essential to enable the client to comprehend all facets of a matter and thereby arrive at a workable settlement which fully deals with all the issues at hand and is acceptable to them. As such, the advocate is a great source of support in what may be a stressful and painful situation, especially if mediation is being resorted to after several years and rounds of litigation. The importance of mediation has also been recognized by the Bar Council of India, which introduced mediation with conciliation as a compulsory subject to be taught from the academic session 2020-2021 onwards. As you're aware, mediation is an alternate dispute resolution mechanism and would help in reducing the burden of litigation on courts. As such, Mediation advocacy is a field which needs to be developed. Advocates must be trained in the same in order to best serve the interests of the parties and in the interests of justice. This would also enable advocates to provide an effective, cost-efficient, and time-efficient alternative to the clients. Our guest speakers today are Mrs. Olusola Adegbonmire and Mr. J.P. Sengh. Mrs. Olusola is a legal practitioner, arbitrator, and mediator from Nigeria. She is a legal practitioner and partner in the law firm of Sola Ajijola and Co., where she has practiced law for the past 32 years. Olusola obtained a bachelor's degree in law from the University of Ife in 1984 and a master's degree in law from the University of Lagos in 1987. She was called to the Nigerian bar in 1985. In her law practice, she has been engaged in a lot of estate planning work and as a consequence has been involved in negotiations, mediations, and various ADR processes. Olusola is a fellow and chartered arbitrator of the Chartered Institute of Arbitrators, Nigerian branch, and is an approved tutor and assessor of the institute, where she is approved to train in arbitration and mediation. She is currently the first vice chairman of the Nigerian branch of the Chartered Institute of Arbitrator. Olusola is a tutor at the Center for Law and Business, Lagos, Nigeria, and teaches applicable laws in international arbitration. She is also on the faculty of the College of Negotiation of the University of Lagos, Nigeria, where she teaches international arbitration at postgraduate level. She is a training consultant for the Lagos Court of Arbitration. She not only teaches, but she also organizes arbitration and ADR courses for various stakeholders in dispute resolution. Olusola is on the board of Kigali International Arbitration Center to date. She is also an estate planning practitioner and a trustee of the Association for Succession Trust and Estate Planning Practitioners in Nigeria. Olusola is an accredited mediator of the Center for Effective Dispute Resolution and a member of the panel of neutrals of the Lagos Multi-Door Courthouse, where she arbitrates and mediates extensively. She is also in the Lagos Multi-Door Court Training Facility, which runs a biannual mediation skills training program. We are very honored to have such distinguished guest addresses on this important and interesting topic. May I first request Olusola to please address us. Olusola, please.
Thank you. Good afternoon from Nigeria. Good evening, Indian time. It's a privilege for me to be here virtually in India. I have visited India twice before, but that was many, many years ago. And I look forward to visiting again. So, well, they've read out my profile, and I do a lot of mediation, ADR, and things like that. And I just want to thank you all for the privilege to be here, because I consider it a privilege. I have a PowerPoint, which I will not share, which I will then send by email, so we can just now and ask questions afterwards, and then I will send it. I will speak from the slide, but I will not send it now, and then you will get the slide later. So I now have 30 minutes, and I will try to put everything as much as possible together. So what is mediation advocacy? I mean, this is like the last day of this training, so I'm sure by now we all know what mediation is, what advocacy is, but just briefly, I'll just say again that mediation is a process. It's a flexible process conducted confidentially, and that's the CEDAR definition, the Center for Effective Dispute Resolution. It says that mediation is a flexible process conducted confidentially in which a neutral person actively assists parties in working towards a negotiated agreement of a dispute or differences, with the parties in ultimate control of the decision to settle and the terms of the resolution. I'm sure that one is very clear. And what is advocacy? I mean, generally, the dictionaries define it as an act or a process of supporting a cause, advocating for a cause. And this Standing Conference of Mediation Advocates, they have a definition for mediation advocacy as the technique of presenting and arguing a client's position, needs, and interests in a non-adversarial way. the difference between mediation advocacy and any other advocacy, litigation advocacy, is one is adversarial, one is not adversarial. I believe we have the same type of legal system, which is adversarial in courts. You know, we go to court and we fight for our clients. Taught from law school, from the day you get into law school, you are looking forward to that day when you're going to go to court and you're going to fight. But mediation advocacy is totally different. You know, it's a way of arguing, of presenting a case, but in a non-adversarial way. So in a way, it's funny, it's argumentative, but it's non-adversarial. You know, so you have to walk a thin line. And it's not just the beauty of mediation as opposed to litigation advocacy is that in litigation advocacy, you're trying to make the case for your clients. In mediation advocacy, you can enlarge the whole scope of things, enlarge the scope, you can add to it, you can remove, and so it makes it so different from litigation, you know. So that's first of all what mediation advocacy is. And then the next thing is, why do we want to have mediation advocacy? Why? You know, one of the major reasons why I think we need to start thinking seriously about mediation advocacy is that things are changing. The sorry, was my network. If you don't mind, if you don't mind, I may have to switch off my video because I think that will help the network. Is that okay?
Yes, please. Yes.
Yeah. Thank you.
You're audible and visible both.
Thank you. So one of the reasons why we need mediation advocacy today is that everything is changing. The landscape for dispute resolution is now changing. In those days, I mean, you heard I was called to the bar like 30 plus years ago. And in those days, everybody wanted to go to court. The best lawyer was the lawyer who could win all the cases in court. And so in Nigeria, we have what we call Senior Advocate of Nigeria. When you have become so good at it, you've been practicing for a certain number of years, you can apply for the rank of Senior Advocate of Nigeria. And so everybody wanted to be senior advocate, but before you can be senior advocate, you have to go to court. You have to have a certain number of cases within a specific time, certain number of high court cases, certain number of court of appeal cases, certain number of Supreme Court cases. And so those were the things people all worked towards becoming a senior advocate. So the landscape was different then. You wanted to win all the cases in court, you wanted to go to court and advocate, but the landscape has changed. Even with companies, with families, I mean, all these things that go to court, a lot of people are now asking, do we really have to go to court? A lot of people are saying it costs a lot of money to go to court. It takes a lot of time. I don't know how short or how fast it is in India, but you could run a case from the High Court to the Supreme Court, and it could take you as much as 10 years in Nigeria. So that is changing. Companies are saying we don't have that time and we don't have that money to spend in litigation. The lawyers will be charging so much money. The clients are spending money on this, the witnesses, this and that. It's so expensive. And so for that reason, parties are saying things must change. And that is where mediation advocacy comes in. A lawyer who is going to remain relevant must be able to now offer the client something different from mediation. I know a lot of big companies, blue chip companies in Nigeria who are saying our budget for litigation, our budget for dispute resolution is not so robust because we didn't set up the business for dispute resolution. An oil company is set up for oil matters. A communications company is set up for telecommunication matters. They're saying we didn't set up our business to go to court. And so we want to spend as little as possible in going to court. And so they are beginning to find that lawyers who can offer them something else are more relevant. We're beginning to tell our clients as well that, do you really want to go to court? Do you think we can propose mediation? Many times they say yes. If we can settle through mediation, we're happy to do that. And I've been happy to help a lot of clients resolve matters through mediation. So now we're finding out that the best lawyers are not just those who can go to court and win. It's those who can help their parties to save time, to save money, and to find a better way to move forward in business. So what are the benefits? Now I've said it, there are benefits to the client and there are benefits to the lawyers. One, I'm looking at the time, I think I still have how many minutes do I have? I don't know who is the timekeeper. Hello? Who is our timekeeper?
You have about 15 minutes, 15 or 20
15 minutes, okay. So their benefits, I said the benefits accrue to the clients, the benefits accrue to the lawyers. One, the outcomes in mediation are more predictable. With litigation, there are too many things at stake. You are never sure. You think you have a very good case, then you have a witness who comes and just says something you don't expect. You think you have a very good case, you have a judge who has a certain bias. You think you have a very good case, they do not find the evidence they're supposed to bring. And so many things can affect the outcome of litigation. Mediation is almost a win-win. And so you can almost tell when you're going to mediation, you can tell your client, this is what to expect. You know what the other side is saying, you know what you're saying, you may have been talking, you know what you can give, what you can take. And when you're dealing with a good mediator who understands the process, it's almost certain to be a win-win. And when it's a win-win for your client and the other party, it becomes a win-win for you. I had a client about 30 years ago, he passed on at the age of 75. Interestingly, he's an Indian, but he had been in Nigeria all his life. We had a matter, and that matter, we had started in court, in the Federal High Court. It was a commercial matter with respect to IP, intellectual property. And one day, just going somewhere, I ran into the lawyer on the other side, and we just started talking. I said, why don't we try to settle this matter out of court? And he said, why not? So I approached my Indian client, who is a businessman, and he said, oh, why not if you can settle? So I went back to the other party. We were able to settle out of court. And I went to my clients and said, this is how much they want you to pay. The first thing, in those days, we didn't have all these transfers and ATMs and so on. The first thing my client just said is, do they want a check or do they want cash? He was so happy. And within a week, we had settled it. That matter would have taken us at least 7 years, 10 years, if we went all the way to the Supreme Court. And the gentleman remained as my client until he passed on at the age of 75. I'm still working for the family. His daughter is still in Nigeria. His son-in-law, they're in Nigeria. I'm still working for them. I've been able to retain them as clients because on that day, I offered them a better option than going to court. He got his goods back. It had been seized. They were saying he had infringed some IP design. So he got his goods back. I was happy. He paid me quickly. I didn't waste time collecting my fees. It wasn't that I would be doing the case for so long. And everybody was happy. It was a win-win for everybody. And like I said, I'm still working for the family about 20 years later. Secondly, the benefits, time and cost is often less than in litigation. So I save my client money, I save my client time, he's happy, I'm happy. Also, we're able to keep a lot of things confidential when it comes to mediation. Things that my clients don't want the whole world to know about. Commercial secrets, trade secrets. And so we go to mediation, which is private, instead of being in an open court. Sometimes the press are sitting in the open court, they're listening to everything. So they're happy. Also, you can have a professional skilled in the area of the dispute rather than a judge. A judge is a lawyer. So he still needs experts to explain this and explain that, but we just have a professional. So I can have an engineer as the mediator. I can have anybody as the mediator. We can appoint somebody who understands much better. And finally, for the courts themselves, it's also win-win, because for the courts, they have more time to attend to serious matters that cannot be mediated, maybe criminal matters. Even now, we've started restorative justice in Nigeria. In Lagos State, they are starting restorative justice, which is a form of mediation, a form in criminal matters. So those are the benefits of mediation advocacy that accrues. What's the role? I think I'll leave the role and the skills because I don't have too much time. Preparation for mediation advocacy, you need to be able to assess the suitability of a case for mediation. Like I said earlier, it's not every case that can go for mediation. And of course, lawyers sometimes face a conflict. I'll tell you something I heard in Lagos when we were speaking about mediation advocacy to lawyers. And one lawyer raised his hand and said, yes, I agree with you that mediation advocacy is ADR. But his own interpretation for ADR was an alarming drop in revenue. Alarming drop in revenue. Because some people feel that ADR means that, oh, you have to finish the case quickly and then you don't get to charge so much money. And so for them, it's an alarming drop in revenue. Maybe another day, not today, I'll tell you the story of the man who sent his son to school. And okay, briefly sent his son to school to read law. The son joined him in chambers and settled a case that the father had on for about 30 years. And as far as the father was concerned, I made all my money from this one case. Now you've gone and settled it. So some people see ADR as an alarming drop in revenue. And so we have to have this sort of things to explain to ourselves that it's not so. So the lawyers, there's a conflict sometimes between personal gain and the client's interest, and we need to try to avoid it. We need to explain in detail to our clients what mediation is all about, the benefits of mediation to them, and we need to understand position as well, because they have a position that they take. So we need to know what is the position of our clients at any time. But one thing I sometimes do when I'm trying to introduce a client to litigation, if it's a family matter, I go into my office and I bring out a file. It's about 3 or 4 files large, so many files all stacked up on each other, which came from one case. So I say, before you start your case, let me show you how much we can go and how far we can go in litigation. So consider, do you want to go this far in litigation or do you want to consider mediation? We would be through in no time and everybody is likely to be happy. I'm not going to promise heaven and earth, but the chances of getting out of it quickly and be is higher in mediation. And of course, try to understand your client's worst case and best case before to be able to, hand important. Some people have problem with mediation is that the client a person really needs. I say a person who needs, and he may not win the case, he may still, in 2 years, he gets $100,000 plus interest. But at that time, his immediate need, maybe for a hospital payment, maybe for one thing or the other, his immediate need may be $10,000. He gets his $10,000 and meets his immediate need, and he's happy, rather than waiting another 7 or 8 years before he gets us, and it doesn't have the skill. And so these are the things that we need to think about, when we're dealing with our clients, because our clients, they come first, So as mediation advocates, these are the things. With mediation also, mediation advocacy, when we go to court, we are limited to the issues placed before the court. With mediation, you can really open up. I handled a mediation once. What came before us was a dispute between two brothers in one jurisdiction. By the time they came to mediation, it's in so many other jurisdictions, we were and then presented terms of settlement, which they then had for the different jurisdictions, and they took it to the different letter from one of the brothers saying he never knew it with one hammer or something we will resolve many disputes. That could never have been possible in court. That can only be possible in mediation. I know that my time is short, and so I'm just going to try to end talking about, there's so many, but like I said, you'll get these slides and you'll see everything in the slides. Of course, preparing for mediation advocacy, always make sure preparation is key. Read the file well, understand your client's position very well, know what is the best case scenario, the worst case scenario. I'm sure you've heard about BATNA and whatnot. And mediation advocates, please always remember to discuss your fees. Your fees. Many people don't encourage, many lawyers don't encourage mediation because they think they're not going to get their fees, or they're not. It's important. Discuss the fees with the clients even before you go to mediation, before you start mediation. Let them know. Because many times they think, oh, but the lawyer hasn't really done much. But the lawyer has done a lot. The lawyer, and Mr. Sengh is going to discuss what the lawyer does in mediation. So you know that the lawyer has a very important role. So please discuss your fees before you go to mediation, so clients don't think, oh, nothing much has been done. And remember, in mediation, when you're in mediation as a lawyer, I do one thing when lawyers come before me in mediation. I say, please take off your lawyer's cap and become anybody. As a joke, I said, who did you dream of becoming when you were younger? Did you dream of becoming a nuclear scientist? Put on the cap of a nuclear scientist or take on the cap of a lawyer. We're not here to argue. We're not here to be adversarial. We're not here to put it to you and be dramatic. We're here to help our clients resolve. And that's why a mediation advocate must be a team player. We're working as a team. I think that was even said in the introduction. We're working as a team, the lawyer, the two parties, on the other side, the mediator, we're all working together to find a resolution which will suit all our parties. So you become a team player, you become a good communicator, a good listener, a patient person, all these, and you have some emotional intelligence. All these are needed to be a good mediation advocate. And in closing, I just want to read a statement or a quote which actually comes from Mahatma Gandhi, and I found it very interesting. And I'm sure you probably, maybe one or two people may not have heard that quote, but I will read that quote in conclusion. I think my time is up. I saw, and I'm opening the quote, I saw the facts of Dada Abdullah's case made it very strong indeed, and that the law was bound to be on his side. But I also saw that the case, if it were persisted in, would ruin both him and his opponent, who were relatives and both belonged to the same city. No one knew how long the case might go on, which is the same thing in Nigeria. I felt that my duty was to befriend both parties and bring them together. I strained every nerve to bring about a compromise and succeeded. Both were happy over the results and both rose in the public estimation. My joy was boundless. I had learned the true practice of law. I had learned to find out the better side of human nature and to enter men's hearts. I realized that the true function of a lawyer was to unite parties driven asunder. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises in hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. That is from My Life is My Message by Mahatma Gandhi. And I think that is the story of mediators and mediation advocates. And I just want to encourage us, especially all of us who are lawyers, to begin to consider our clients, to begin to consider how we can help them in their business, in their family, in different matters, to find a better way that saves money, that saves time, that saves relationships. Thank you very much.
Thank you so much, Olusola. That was very interesting, especially the take you had on the confidentiality which is connected to mediation, which is appealing to parties. That was a very different facet which had not occurred to us. So thank you so much. Our next guest speaker this evening is Mr. J.P. Sengh. He's a senior lawyer, seasoned mediator, and a mediator trainer. He's a well-known civil, commercial, and arbitration lawyer and an accomplished mediator, and he has been the founder, organizing secretary of Samadhan, the Delhi High Court Mediation and Conciliation Center. He received his basic training in mediation in India and his advanced training at the S.J. Quinney's College of Law, University of Utah, and the Strauss Institute for Dispute Resolution, University of Pepperdine, Malibu, USA. He has trained lawyers of several high courts and district courts in the country, and also judicial officers at Delhi Judicial Academy, Jharkhand Judicial Academy, and has conducted workshops for students at various law schools. He has been appointed an observer by the Mediation and Conciliation Project Committee of the Honorable Supreme Court of India for observing the training of the trained mediators. He was a member of the panel constituted by the Supreme Court for recommending legislation on mediation. He has conducted over 400 mediations and has been appointed mediator in several important and large commercial disputes by the Supreme Court and the Delhi High Court. Mr. Singh, may I kindly request you? Mr. Singh?
JP, unmute yourself.
Yeah, thank you. Thank you, Prabha. Thank you, Olusola. The mediation movement started in India also with a lot of resistance. You know, we had seen the district court center being torn down. And it was again perceived as an alarming drop of revenue. Yes. Now, so far as advocacy is concerned, let me, there are two meanings to advocacy. One is a formal meaning, which talks of giving of public support to an idea, a course of action, or a belief. They say mediation is an idea whose time has come. And the second is the technical meaning. That is the work lawyers who speak about cases in court of law. Now, I'll try and combine both these two concepts in my address. We as lawyers are trained in advocacy, typically referred to as adversarial skills. When parties are in court, we witness attack and counterattack. Each blames the other for the situation they are in. There is retaliation, and the situation goes from bad to worse. Both try to get their last word in. Both are trying to come up as a winner in the battle. In court, parties act like adversaries and no one likes to give in. Each wants to win the contest. Now, unlike litigation, mediation is non-adversarial. Instead of a face-to-face confrontation, it encourages parties to engage in problem solving. It guides parties to a mutually satisfactory agreement. It does not believe in blame game. It is not looking for a winner. It brings about win-win solutions for both the parties. Now, mediation practice is distinct from litigation practice. You may be a good advocate in court, but mediation requires a different set of skills and qualities. It is therefore important to undergo the basic mediation training and understand the process so that you can accordingly prepare the parties and also assist them in resolving the dispute by cooperative problem solving. First of all, let's understand, why do parties reach the portals of the courts? Every dispute goes through three phases, as is explained by the NBC model: naming, blaming, and claiming. Now, let's look at this framework for studying the process by which unperceived injurious experiences are or are not perceived. Now, this is the naming stage. Do or do not become grievances, the blaming stage. And ultimately, disputes, the claiming phase. Now, let me explain this to you with an example. There are several injurious experiences that never rise to the level of becoming a conflict. Injurious experiences become conflicts when they become significant enough for us to perceive them as unwanted and disvalued. At this point, we name them as conflicts and they become part of our subconscious lives. For example, I don't like my job. Now, conflicts escalate to become grievances when we blame a specific person for causing us a perceived injury, harm, or injustice. For example, I don't like my job because my boss is too demanding and doesn't pay me enough money. Grievances escalate to become claims when we demand that the person who has wronged us is responsible for remedying the harm. For example, I tell my boss, you need to assign me less work and pay me more money. Now, claims escalate to become disputes when our demands for a remedy are rejected in whole or in part by the person we deem to be responsible for the harm. Now, let me take the example forward. My boss tells me, if you don't like working here for what I pay you, you can quit and I'll have someone else. Disputes become lawsuits when we engage lawyers to reframe these rejected claims into a legally cognizable cause of action and file them as cases to be decided by the court. Now, dispute perception is conditioned by the legal consciousness of a person. And that's why sometimes they don't arise. In court, a lot of emphasis is given on law and context. And it does not focus on the psychological and the internal room of the dispute. The role of the lawyer in this context should be to provide room for the parties to experience empowerment and recognition, and to support individual education of self-assertion and rights acknowledgement through legal consciousness. Implementation of this understanding-based approach requires change in mindset, change in how we approach conflict resolution. Traditional legal approach is essential, because it has played a critical role in our society. However, litigations in court has become adversarial. Coercion, manipulation, and even dirty tricks are used for winning a case. This results in a winner and the other as a loser. The decision ordinarily leaves deep scars, psychological, emotional, and financial, on both parties, not necessarily on the loser only. Now, so far as role of the lawyers is concerned, some believe that mediation is meant to support the parties in their making voluntary decisions together, and that the parties are fully informed about whatever they might find relevant to the decisions they wish to be made, they will be making. In that sense, they feel the process need not be dominated by the law or the lawyers. They feel in most mediations, a party doesn't even need a lawyer's direct participation. Parties who are mediating are less likely to need an advocate because they are trying to work together to solve their problem and not trying to convince a judge or an arbitrator of their point of view. At most, a mediator can direct the parties to seek legal advice on the law relevant to the dispute and assist the parties in reviewing the terms of settlement so that they are enforceable in law. Traditionally, lawyers are rivals. For them, the way to resolve disputes is based on rights and law, which only a court can decide. They are trained and experienced in adversarial advocacy. They perceive dispute resolution as a division of a fixed pie, and they want the larger piece of the pie for their client, obviously. In mediation, parties are decision makers. The responsibility for the outcome stems from their right of self-determination. Let's examine, in context of mediation, what should be the role of a lawyer. Now, what is witnessed by us today are 5 kinds of participation in the mediation process by the lawyers. Dr. Olivia Rundle describes them as, first, the absent advisor. The lawyer will provide the substantive and procedural advice to the client, but would not attend the mediation sessions. Now, this is something which we witnessed so clearly. The second, the advisor observer. Now, he prepares the client for mediation, attends the mediation sessions, but does not interact with the mediator or the other party. So he's the silent observer, the advisor observer. The third is the expert contributor. He participates in the mediation process, but limits his input to providing legal advice to his client. He will help in reality testing and realistic alternatives to settlement proposals, however, doesn't negotiate on behalf of his client. Now, this is the expert contributor. The fourth, the supportive professional participant. Both the lawyer and the client participate directly in mediation negotiations and work collaboratively towards an acceptable outcome. Besides reality testing, he also assists in drafting a mediation settlement. The fifth is the spokesperson, and you would find that happening also in our courts. Lawyers, and especially in the mediation sessions, the lawyer speaks and negotiates for his client. Client is silent. This is particularly apparent when there are capacity or power imbalance issues. This role is more aligned with the traditional advocacy within the adversarial system, and they are not able to give up that hat. The roles of expert contributor and supportive professional participant shows the perfect blend of mediation advocacy. Mediators value these roles as helping in self-determination and client empowerment, as well as legal representation in mediation. So these are the 2 roles which any mediator would expect a lawyer to play. Now, there is a paradigm shift from traditional rivalry to interprofessional collaboration. Mediation is fast gaining acceptance and has become an integral part of our justice dispensation system. Lawyers are successfully adopting different roles in court-annexed mediations. Statutes incorporating mandatory pre-litigation mediation put more onus on the lawyers to get trained and effectively assist their client in this problem-solving approach. Now, we talked about change in mindset. Training brings about a change in mindset. Lawyers should encourage parties to resolve disputes through negotiation. explain the advantages of the mediation process, and prepare the parties for the process. Now, Olusola also talked about preparation. No, they say if you land up in a negotiation without preparation, and most of us do, we'll go and look at what the other side has to offer. They say it is like negotiating with your eyes closed. You don't know what the offer which is going to come from the other side. You should accept or reject. You may accept an offer which you should have rejected. You may reject an offer which you should have accepted. So therefore, preparation is a must before you actually go in for any mediation session. In adversarial setup, the biggest casualty is communication between the parties. Lawyers should help facilitate discussions during mediation and maintain supportive and cooperative demeanor. Help uncover interests of the parties as well as protect their interests. They play an active role in generating options, evaluating them, and in reality testing. Now, the problem, with reality testing, which most mediators find, Olusola talked about Vatna. See, expectations formed through legal counsel's analysis can present the most challenging to reality testing. Any conversation between the counsel and the client about their likelihood of success can create unrealistic expectations, even if unintended. So when a mediator does risk analysis, leading a party and their counsel through a reality testing exercise that leaves counsel looking foolish. Excuse me. And their clients questioning their judgments. So reality testing is a very, very difficult, exercise which needs to be done. And actually, this exercise should have been done by the lawyer before he makes the party join the mediation session. At the end, it is important to assist the parties and the mediator to draw up an efficient settlement and make it binding and enforceable. Now, let me sum this up to you in the form of a bullet point. Lawyers' role before mediation. Lawyers should encourage parties to resolve the dispute through mediation. Encouragement. Lawyers should also be trained so that there is a shift in the mindset. They should explain the appropriateness of negotiation and mediation process to the dispute to the parties, advise them on the law and rights approach to the dispute, appropriate to the dispute, inform parties about the advantages of mediation, and prepare parties for the process as he prepares them to go to court. Now, during mediation, maintain supportive and cooperative demeanor, help facilitate discussion, assist them in uncovering their underlying interests, help them in protecting their interests, assist them in communication, assist them in generating options, because most parties can't generate options. Help them in evaluating those options, that is reality testing, and assist them in drawing up an efficient settlement. Now, that is during the process of mediation. Now, after mediation process is over, help them in completing the legal process for purposes of making the settlement binding and enforceable. Help them in enforcement of the settlement compliances. All the compliances need to be done. And that's again, the lawyer's role comes in. Now, what we have seen, that lawyers have shifted their role from advocate to advisors in mediation. Here, lawyers do not speak for their client. Instead, they offer advice, guidance, and information. They act as problem solvers. They help to resolve rather than provoke. Most importantly, they bring reality check in their discussions, which help the parties in their perceptions regarding strengths and weaknesses of each other's case. We must realize, while the conflict may be causing the parties to be alienated from themselves and each other, it has not destroyed their fundamental ability to move, of course, with assistance, but of their own volition, from weakness to strength, or from self-determination or self-absorption to recognition of others. It is said, when you make the human connection, the problem usually solves itself. The most important skill to run a mediation conference is the ability to develop an empathic relationship with the disputants. Indians are generally perceived as being collectivist. Though John Robinson, the famed economist, says, whatever you say about India, the opposite is also true. Indian society promotes interdependence and cooperation, with the family forming the focal point of this social structure. We have come to believe that mediation's greatest value lies in its potential, not only to find solution to people's problems, but to change people themselves for the better in the very midst of the conflict. That is transformative mediation. Parties to the dispute in a way are solved and reconstituted as the residue of the mediation process. It is actually a process of healing. Thank you.
Thank you, Mr. Singh. I thank you both for a very interesting and informative session. We will now be taking questions. If I may take the first question, Mr. Singh, will be, why are parties still resistant to mediation, though it is self-determinative? What is the mindset which is blocking them?
It's lack of awareness. See, unfortunately, they say when you have a hammer in your hand, every problem looks to you like a nail. All that the parties have seen is the court system which the Britishers left for us. So every dispute lands up in court. I'll see you in court. That's the term we usually used whenever the parties are in conflict. I'll see you in court. They don't know that there's any other method by which that dispute could be resolved. And that's why probably this resistance. And
how do we create awareness about this alternate dispute mechanism? What can be done to promote it?
I think the role of media, the social media today plays a very, very important role. And secondly, like all the three stakeholders, I mean, the courts are encouraging today. If you see the court annex mediation centers, yes, courts have been very encouraging, sending parties to mediation, to try mediation. And the results have been very encouraging. And parties today realize that matters which could have taken years in courts, we have 90 days within which the matter is to be returned back to the court, and matters are getting resolved. So courts are encouraging. The government is supportive. You see, we call this a three-legged stool. The bar is supportive. So today, I mean, though there was resistance in the beginning, today the bar is supportive. Bar itself sends its own matters before filing them into court for pre-litigation mediation. So the court is helping us. The government is helping us. So all we today need is the awareness being spread through the process, through the media, print and electronic both. I think probably and yes, community mediation. You see, today that is also taking over in a very big way. And if their parties' dispute can be resolved at that level, I think a lot of awareness will set in.
Thank you, Mr. Singh.
I think another reason why, I just want to add, I think another reason why people don't want to go to mediation is that people think that the person who takes the first step to mediation has a weak case. And I think that has been encouraged by lawyers. So they make you feel if you have a very strong case, you have no need to go to mediation. You can get all what you want from litigation. And so we have to, and that's why, I mean, what Mr. Sengh is saying is very correct. The courts are the best people So in Nigeria, we have what we call the Lagos Multi-Door Courthouse, and we have the Multi-Door Courthouse in many states right now. And so the courts just send parties to the Multi-Door Courthouse. And we also have, when it started, it was once a year. Now they have it twice a year. It's called a settlement week, when at least maybe 1,000 cases are taken from the courts and sent to mediation for mediators to try to settle them within 1 week. So it's called time-bound mediation. Each mediation, you have just 3 hours, and the success rates are getting better. You know, so I think it's the courts, like Mr. Singh has said, they have a very great role to play, because parties are each thinking who will blink first, who will bail the cat first. If I say let's go to mediation, it means that my case is weak, which is not so.
Thank you, Olusola. Jayesh will come up with the next question.
Yeah, there was a question from Advocate Kavita Solanke. She was asking a very practical question, that can the mediators and the parties create a WhatsApp group of something for communicating, whether it will affect confidentiality and all those things. I want a response of both of you.
Olusola, go ahead.
Okay. No, I was going to say that it depends. If you create a WhatsApp group for all the parties, then what you have created to me is like a joint session. But you cannot have a WhatsApp group for private sessions, because in mediation, you have to have confidentiality in the caucus meetings or in the private sessions. So, I mean, I don't know. I don't do too much on social media. I don't know if you can be in a group and then have private chats. I don't know. But the problem with that is that in mediation, you have a time when you have private sessions. And if you are all on a group together and you can all read what each other is saying, then it defeats the purpose of confidentiality. I have always believed that confidentiality is one of the bedrocks of mediation. It's one of the things that makes mediation work, because you can tell the mediator what is really bothering you without the other party knowing. You can make confessions, kind of confessions to the mediator. Well, I know that, you know, I really shouldn't have done that. If you're on a general WhatsApp group, you can't do that. Over to you, Mr. Singh.
You see, Jayesh, you know, we even, when we do our opening statement, we tell parties we'll be making notes, and those notes are to be destroyed after the sessions are over. And what WhatsApp will do, it leave a print. And those, you know, what were discussed, what we talked about is irrelevant. All that actually ends up is either a non-settlement report by the mediator without giving any reasons, or a settlement which parties enter into, and at the end that's sent to the court, or it's ultimately, like if it is pre-litigation, it becomes binding. So as was rightly said by Olusola, confidentiality is the bedrock of any mediation process. And therefore, WhatsApp, though we do, you know, a lot of ODR has happened during the COVID season, and Delhi High Court is done wonderfully well. You know, a lot of matters got resolved. But there is no recording. I mean, it is made sure that there is no recording of any kind of and parties, but we found still were not willing to open up with some information online, because they were really not sure whether the other party could record that. And though, yes, we had the you know, privilege of private sessions through ODR, but still there was certain information they were very, very hesitant in disclosing. And therefore, that's a big challenge when you talk of WhatsApp communication happening.
JP, if you will permit, I'd like to add, you see, like here in our Supreme Court Mediation Center, when we are going on for, you see, the virtual mediation especially, we are making WhatsApp group, but we are using WhatsApp group only for the purpose of informing the parties about the date of session. Nothing beyond that. We are not putting any information or the discussion which is taking place between the parties on the WhatsApp group. So to that extent alone, if we are using the WhatsApp group, it continues to maintain the confidentiality, as well as, you see, it becomes a source of information between the parties. And if you see something is to be asked between the parties, which is certainly not confidential in nature, can be put in that group. To that extent, we are using it, and it is being used very successfully.
Olusola, the next question is for you. You had indicated that during the mediation process, the advocates should indicate their fees. But generally, how beneficial is mediation advocacy to the career of an advocate, especially if they're starting out and they want to make some money also? So, and I don't know how.
Okay, that's a very good one. Now, I think it is very beneficial. Now, the problem, and I had explained that, and I don't know if it's a problem you have in India. In Nigeria, for example, many people start out as lawyers and ultimately they want to become senior advocates of Nigeria. It's a big title. Okay, it's the equivalent of QC. I'm sure most of you would know QC in England. Now, you cannot become QC if you do not go to court. You cannot become QC if you do not have a number of cases you have handled. And so in Nigeria too, QC, SAN is the equivalent of QC. You cannot become an SAN without a certain number of cases in the High Court, cases in the Court of Appeal, cases in the Supreme Court, and all within a certain period of time. So within 2 years, at any point, you must have a certain number of High Court cases you finished, Court of Appeal cases you finished, and Supreme Court cases you finished. Now, this discourages many lawyers. Many lawyers start out young and they want to become SANs. They want to become this, they want to become that. And you have to go to court to do these things. And so one of the things we're arguing about and we're advocating for is that there must be another way to attain these milestones without going to court, using mediation. So because of that, people will not encourage their clients to mediation because they believe if all we do is mediation, then we can never become SAN or QC. That's one. Two, like I said, a lot of people feel it's an alarming drop in revenue. You don't make money. I totally disagree. Totally. Now, remember the case I talked about? I met up with the other lawyer. We resolved the case. I was able to earn my fee much faster than I would have earned my fee if we had gone to court. Now, some may say I would earn more if I had gone to court, but I would earn more over a longer period of time. I earned a little bit less, and I don't even think I earned less. I think I charged the client the fee. And that's why I said, discuss the fee before you start. I discussed my fees with the clients. I let them know this is what I will charge. And so I said, but we're just going to court to settle. I said, no, I am using my professional expertise to help you resolve your dispute through mediation. And so you must pay. I help them to understand that I am actually serving you better by helping you to resolve your disputes in a shorter time, spending less money, and that is why I should be paid my fees. And so I think we need to start also talking about fees, because mediation always looks like it's something that there's no money in it. No, we are rendering a service as mediation advocates. We're rendering a service to the client. We're helping the client to get much more, because if I can help a client get, let's say, 100,000 in 1 month, as opposed to 500,000 in 10 years, I think I'm doing the client a good service. But we need to let the clients understand the service we're providing them and why they must pay for it. I think that we stand to make much more, because I can do many more mediations in the same time. I'll do only one litigation and I'll earn my fees.
Can parties ask for their mediator? Can parties ask for a particular person to be made mediator in their proceedings? Because in Supreme Court,
yes.
Okay, because it is just assigned.
Prabha.
Well, it doesn't. In the Lagos multi-door court, the Lagos multi-door court just assigns mediators. But
Yes.
if both parties agree, the same thing with us. But I believe if both parties agree that we want this person, there's nothing wrong with it. After all, people have private mediation businesses,
Yes.
a private mediation service, and the parties go together to that person. I've started as a private mediator as well. Parties come together to me privately and ask me to mediate the case for them. It's their choice.
It's their choice.
Prabha,
Thank you. Yes.
in terms of the Indian circumstances, let me just tell you this, just add this. You see, the movement here was basically steered by the MCPC and the court annex mediation centers. And parties really do not have any idea about who's a good mediator, who's available. So you rightly said that in court annex mediation centers, a neutral mediator is marked the matter by the court.
Yes.
But when it
Yes,
comes to parties, self-determination, you know, you will soon find, like any good doctor or a good lawyer, even once you have a pool of mediators, parties' right of self-determination, the right to have a choice in selecting a mediator would become very, very, very much in vogue. And also, let me tell you, parties will ask for a particular mediator and pay for his fee. That's the future that we envisage will happen. We have the vision for in India.
Thank you, sir. Jayesh?
Yeah, there is an interesting question along with that, like taking mediation as a career. That was the thing. The question was regarding fees of the lawyers. Now, one step ahead, there's a question that comes, what is the scope of those lawyers who concentrate in mediation to get into judicial positions, like judges and other things? Because this is an alternative dispute resolution, but do we actually not require judges who are by heart mediators or who can handle mediation? So what is your take on that, both of you?
Olusola,
I don't understand. I'm trying to understand. Are you saying that is it possible for mediation to be made a career, and that can a mediator then go on to become a judge? Is that the question?
No, the question was, what is the scope of, if somebody is practicing mediation, whether is there any scope for him to be elevated? But in Indian system, I don't get any positive. If somebody is clearly doing mediation, I don't know.
Jayesh, a lot of lawyer mediators have been elevated from Allahabad.
Okay.
And
Yeah,
and
I was going to say.
I know of some lawyers who were trained as mediators and practicing also mediation have been elevated. That's not the question. Yes, you are right. And any other mediator who's not a lawyer may find it difficult. Like even today, even professors of law, I don't think very rarely would be, nominated to the bench. So therefore, those difficulties are there. But yes, it all depends on how the mediation actually, the moment takes over tomorrow. And if you are a person with a legal background, I'm sure judges would be willing to encourage them to, because I mean, I have often heard our judges say, after attending mediation sessions, their whole perception, in court changed. Instead of earlier, like, they would not encourage a party to speak up in court. But having attended a mediation session, they feel that there's no harm in actually also hearing the party if the party wants to say something, because it's ultimately party's dispute. So a change in mindset is happening. Yes, of course, it will take time.
Yes.
If I may add to that.
In the multi-door court, in the courts annexed mediation, the Lagos multi-door court and the other states multi-door courts, we now have ADR judges who are trained in mediation and who just sit as ADR judges. So I think there is, like Sengh is saying, the future is bright.
No, in Indian Constitution, there is an interesting provision for appointing a jurist as a judge in Supreme Court. But I don't find that in High Court. But I have not seen any jurist appointed as like in Supreme Court who is coming under the definition of jurist.
Jayesh, that's why I said professors in law, are eligible, but unfortunately they have not been appointed so far.
Yes. Thank you.
We have a question from Shobha. She's asked, the rewards of court annexed mediation are that the parties are happier, the courts are less burdened and spared for cases that deserve handling by courts, and the system has become cost efficient. The litigants feel that they're given an opportunity to play their own participatory role in the resolution of disputes. Would you say that ADR services under the control, guidance, and supervision of the court would have more authenticity and smooth acceptance? How should this be implemented? Any of you could answer this question, Mr. Singh or Olusola.
Prabha, actually, as I said, the end product of a mediation is not only resolution or a solution or a settlement. The purpose of mediation is to transform parties themselves so that they can take their own decisions and the disputes get dissolved. As I said, dispute solves the parties and the parties become a residue when they go through the mediation process. So that's the purpose of mediation. You see, when we start talking of settlement rates, matters getting, off the court's docket, that is why it has happened, because the court today felt burdened. And, the matters, because of the judge population ratio or whatever reason, that there's influx is more than the matters getting resolved. But the issue is that what mediation looks to is not a solution or a settlement of a dispute, so that numbers become less. And therefore, to say that, court annexed or a court supervised mediation is much better than private mediation is not correct. Because private mediation can bring about the same. See, it's the dispute of the parties. Parties need to be transformed. Parties need to get out of that conflict. And actually, they say, therefore, the positive part of conflict is that actually it gives you an opportunity to grow, to learn and grow. Disputes or conflicts are never to be perceived as only negative. And therefore, saying that only the better results can come through the court supervised mechanism, I don't think that's correct.
And let me just add to that. Yes. What we say is that the process works. The process works. The truth about mediation is that if you walk the process correctly, then parties will resolve whether they're doing it under the supervision of the court, whether it's being done in a private capacity. If the process is carried out properly and parties have settled, that's all that matters to the parties. So if they're under supervision, if they're not under supervision, if the mediator follows the process and everything works out, parties would not even consider whether they were under mediation. I mean, they were under the courts, they were not under the courts. Of course, for enforcement, you need the courts. But then that is in a very, very rare number of cases, because parties have come to the conclusion by themselves, whether they were under court supervision or not. Ultimately, it was the decision of the parties. And so you should not be needing a court to control them before they do the right thing. And even if they don't settle, whether it's under, you're not going to force them to settle because it's under court supervision. I don't think the settlement rates will be higher because they're under court supervision or less because they're not under court supervision. It really is the decision of the parties to settle or not to settle.
Absolutely. Jayesh?
What we have in Lagos, what we have in the multi-door court system is that even if you did not settle in the court annex mediation, even if you settle outside in a private mediation, the Lagos multi-door court allows you to bring your settlement agreement to court to be made a court judgment. So it doesn't really matter whether you did it there or you didn't do it there. If you need to go beyond that settlement, you can still bring it to court.
Now, there is a question which says from Patrick, is not the term ADR judge an oxymoron? Because ADR is alternative dispute resolution, and so judge comes only in judicial system. So how you respond to that?
Jayesh, that's why we call it appropriate dispute resolution. We don't call it an ADR, an alternate to court. It's complementary to the court system.
Well,
We have a question from Advocate Savio. He says, my question is to Mr. Singh. What is the necessary requirement to be appointed as a court-appointed mediator?
See, each court has its own, rules, and they have their own, I have, like, for some courts, the requirement is 10 years practice. Some courts requirement is 5 years practice. Some courts require 7-year practice in law. And therefore, this would be dependent on which court you are practicing in. And therefore, it is governed by their own constitution, the rules that they have framed for themselves. So, but yes, because it's, these are matters pending in court. So therefore, one, you have to be a lawyer. And secondly, we always, since we have court annex centers with every court, we encourage that you should be a member of that bar. and to practice. You're practicing there, and of course the number of years that you practice, that makes all the difference. And your mindset. You see, you may today let's as I said, it's important to understand that I may be a good advocate, but I need not be a good mediator. So don't feel that I'm not, merely because I've done the mediation course, and therefore I should be appointed as a mediator, and while I'm not being put there, or I'm not actually been able to do well in mediation, that should not disappoint you. See, these are life skills. When we talk of negotiation and communication, you'll find that these are skills which are good for you even during your day-to-day issues in court, or with the peer group, or with elders, or with your boss. So therefore, these are skills which you need to imbibe. You can be a mediator, you can be participating in the mediation process as a lawyer, you could be advising parties on how to go about in mediation. So therefore, all these roles, you can be an in-house counsel, in-house mediator for a large corporate firm or a organization, where the disputes, they want to resolve those disputes there and then, nip them in the bud. So there's so much of scope available for you to act. So therefore, don't feel disheartened that merely because Court Annex Center requires this kind of these are the qualifications required. There are other avenues which are not available to you. There's so many other avenues which you can avail of.
And Mr. Singh, how easy is it for a litigating advocate to become a mediation advocate? Because it's quite different mindsets and skill sets are required, like you had mentioned. So how easy is it?
See, as Olusola said, unfortunately, if you advise your client to go in for mediation, he'll think that my lawyer is telling me he has a bad case. And that is not so. And probably that's why you have now a lot of laws or statutes incorporating mandatory pre-litigation mediation to get over that psychological barrier, so to say. But I think that you can, as a lawyer, practice on this side. But unfortunately, you must realize, these are two different hats that you wear. When you talk of a judge mediator, the problem is a person who's been used to delivering judgment, who's been used to ordering, who doesn't have the patience to actually go on, listening to the repeated woes of the client. See, because when the parties come to you, they're so full of angst. And those emotional issues, and we say parties and the person, party and the person gets mixed up. Those, unless you are able to separate those emotions, rationalization does not set in. So therefore, it's a different mindset. You are right. It requires a different mindset. But it can come to you by practice. A lot of us were, trained in advocacy. Mediation started 16 years back. 2006 is when the center at Delhi was, Delhi High Court set up. Then Chennai started in 2005. So we are 16, 17-year-old. And therefore, we have changed our mindset today. In courts, when they see you, they say, why don't you take the matter and get it resolved? So the fact that you are now known as a mediation advocate is good enough a recognition that you will get in court.
Jayesh?
Yeah, I don't find any questions from the audience here, but still, like the interesting point is now we are all, after hearing the lectures, we have been converted to mediation advocates in mind and in practical sense also. We all have the courage now to take up mediation as a very serious business, being an advocate also. Now one question comes, is it necessary that training of 40 hours to become a good mediator, or is it compulsory? So somebody has asked this question.
Jayesh, that's a threshold training. Merely because you do a 40-hour training does not make you a mediator. You have to cross that threshold to open up the beautiful, magical world of mediation for you. So it is first, Justice Serious Joseph put it so well. He says, look, even surgeon cuts, so does a butcher. You want to be a surgeon or you want to be a butcher? Everybody said, I want to be a surgeon. But if you want to be a surgeon, you have to qualify to be a surgeon. So therefore, training is a must, because training opens up your thinking about how the mediation process works, and it's only thereafter, what is important is thereafter you must sit with a senior mediator who's been mediating, and what we are saying as a co-mediation. Acquire those practical skills on the spot. And thereafter, you will be in a better position to mediate yourself. So unless you have that practical training in mediation, just merely doing a 40-hour mediation course does not make you a mediator. Right.
One question which we seem to have on the chat box is from Advocate Ritu. Can a mediator advocate do mediation as a private business? So I don't know how.
And lot of people have left, abroad. I'm told people have left advocacy and have started just doing mediation. In India, we have some of them, Bangalore camp. Jawad is here I can see him on the screen. They have left their, totally their litigation practice and are devoting their full time to mediation. And it is a process, and I'm sure, as I was telling you, the market's forces will determine, and tomorrow people will ask for you by your name. Once, why don't we go to a particular surgeon to get a heart operation done? We choose a person, right? Similarly, tomorrow people will choose you. Once you are known as a good mediator on a particular site of a domain knowledge or a process knowledge. I mean, there are so many combinations which can happen. And so therefore, I think sky's the limit.
One more question is there any current developments in relation to the use of ADR, highlighting any policy by courts to sanction failure to use ADR? This is from Shobha again.
Prabha, can you have the question again?
Is there any current development in relation to the use of ADR, highlighting any policy by courts to sanction failure to use ADR? If you don't use ADR, are there any sanctions imposed by the courts?
I don't think we have developed so far. Of course, costs can follow the result, as they say. So if you have actually not opted for mediation or refused to go for mediation, sanctions can be in terms of costs in future that you pay for the other party's costs. Or, sorry, even if you succeed, you may not get your costs. If you have, not willingly gone in for mediation at that stage. So therefore, but yes, today I don't think there's any judgment of our courts or the Supreme Court which has dealt with this issue.
Now there is a question that if one of the parties are not agreeable for mediation, one party is agreeable, the other party is not agreeable. Normally, we say that both of them should be agreeable, but in the context of the new Commercial Courts Act 2018, there is a court mandated mediation before you enter the commercial dispute to the court. So how far is it justifiable? That's a question.
See, what the mandatory mediation tells you is to go and try. It doesn't tell you that go and settle. So your right of self-determination still continues. Is you have that choice whether to resolve or not to resolve the dispute on the mediation table. So therefore, a mandatory mediation only says you must go and explore this possibility. And you may find, you see, therefore I'm saying the resistance sometimes stems from the fact that you feel that you have a great case. Because as I told you, the expectations built by the lawyers. We'll win, we'll surely win in court. And we know of cases where we won before the first court and the second court and lost in Supreme Court. So therefore, that uncertainty always remains. So if on the negotiating table, that's what your Vatna and Bhatna is about. If what is being offered to you is better than what you will get in court, take it. Question is sensitization of parties, sensitization of lawyers. Once that happens, parties will choose mediation, even if they are not forced. See, today, the reason why mandatory mediation, because parties are yet to try mediation. Let them go and try. Once we have a pool of mediators, enough available, I'm sure this process will work. Parties can go and try mediation. If it doesn't work, Nobody stops you. Even the urgent reliefs, you can go to court. Even the Commercial Courts Act doesn't bar you from coming to the court straight away. Even during the pendency, the court can also send you back again for mediation. So therefore, mandatory mediation does not deny access to court.
And I think the beauty of mandatory mediation, which we have, in fact, now, since the last 2 years, you have to show that you have made an attempt to settle. We have these protocols that you must follow. It's part of the High Court rules now. They're mandatory protocols before you can go to court. And the beauty of all this mandatory mediation for me is that a lot of people will never go to mediation on their own. The court, quote and unquote, forces them to go to mediation. And then they get to mediation and they find out it's not as bad as what they thought. I have sat on so many cases where people come to mediation and say to me, I really don't want to come here. The court has made me come here. Let's just get over it and let me go. And we start the process. And the same person who says, oh, I don't have the time. In fact, they now take all the time because for the first time, they have an opportunity to be heard directly, not through a lawyer, but to actually hear. And then when they hear the other party, many times they discover things are not what they think it is. So that's why I always support mandatory mediation, because it makes them at home. You have to settle, but you find out when you come and you follow the process, the chances of settling are very high, even though when you came, you did not want to settle. So, I think it's one way that pushes people into settlement, and then the rest is in the hands of the mediator and the parties. But at least you get the opportunity to start.
But Olusola, I think in certain countries like the USA, the prohibitive cost of litigation also leads them to settle. I think before, not many people approach the courts there, I think. So why isn't that mindset there in other courts in other countries also? Like the first step, like you said, you think it's a weak case, so you don't want to go for mediation. But even yeah, please.
I think with time and with the way things are going globally, within the Singapore Convention, it's opening the eyes of many people to mediation. I think we're going to eventually get to that point where everybody has to try mediation. In fact, what we now have in Nigeria is the Court of Appeal Mediation Program, which means even after you have won your case in the High Court, the other party can still ask for mediation on appeal. The good that does, even though you've won your case on appeal, you've won your case at the High Court, you could be on appeal for another number of years. And really, all you wanted to prove was that I had a good case. Now you've proved that you have a good case. You're actually ready to settle. We now have the Court of Appeal Mediation Program, where even after you've won your case in the High Court, everybody knows you are the winner, you can now sit down with the other party and say, okay, let's talk again. And that's very helpful.
Thank you. There's a question from V. Ramakrishna. How does mediation process work in rural areas or at lower court levels? Mr. Singh, if you could take this question.
That is what we've been saying. We need to indigenize the whole mediation process. And that's why you'll find the mediation literature being converted into the regional languages. See, that's where we are reaching. And in our trainings also, we say you should have lawyers or trainers from that particular region who can converse in the language of the person concerned. See, for us in India, we are a different kind of a culture, where every 200 miles, I think the culture changes and the language changes. So therefore, we need to have, a pool of mediators who can understand the regional languages. Because in communication, you can miss, the turning point in case if it is translated. You must be able to understand the nuances, when you're listening to a party speak in his or her own language. So it's very important. And then till we achieve that, we today actually, we are mostly in cosmopolitan towns where it's doing very well. Delhi, Chennai, Bangalore, Mumbai. Reason being that these are cosmopolitan towns, and then slowly it's actually going down towards the districts and mofussils. Once that happens, I'm sure it will reach the doorstep of a party. And then, of course, encouraging community mediation. So once that happens, it's bound to reach the person even in the Mofussil and the villages.
Thank you, sir. Jayesh?
Yeah, I have two
Someone
questions.
wants to know if yes.
No, you please go ahead.
I was answering one question because I found it very interesting. That does a mediator have to be a lawyer? And I mean, that I always find interesting because in some parts of the world, they actually do not allow lawyers to be mediators because they feel the training of the lawyer is too adversarial. And so definitely mediators do not have to be lawyers. I just find it very interesting always when I hear that question.
Yeah, thanks. Now, there are two questions. One is from Senior Advocate Rajiv Datta. He's asking about whether mediation should be made part of the compulsory college curriculum. And another question from a law student, perhaps, Baharani Murmu. She is asking for advice for for students who will take up mediation as their careers. So these two questions are connected, and one's come from a senior advocate, and another comes from a student. So I think that have a relevance. So please, I want a response from both of you.
Jayesh, abroad, as was being said by Olusola, peer mediation is actually prevalent even in schools. We have now started,
yes,
mediation training in colleges, law colleges, third year and fourth year law students. I mean, almost, I visited about 9-10 of them all over the country, and I'm sure others would have, visited other law colleges, where now students are being given training in mediation at that particular. You see, as I said, in the court annex mediation centers, probably the problem is you are handling litigation which is pending in court. So you cannot have a law student or a person who is not a lawyer handle those litigations, because you need to have domain knowledge also besides the process knowledge. And therefore, that becomes difficult to have a non-lawyer deal with matters which are pending in court, or law students handling matters pending in court. But the training, the change in mindset today is happening even at the level of the schools and also in the level of law colleges. So far as future is concerned, yes, you can. There are a lot of universities which are offering these courses abroad. Pepperdine Strauss Institute is #1 in the US. As was said, we went to Salt Lake City for our TOT. So there are ADR courses which are available abroad. As I said, the future in India will all depend on the market forces. The mediation law is on the anvil. The objections and comments were invited on the draft law. That's now pending for promulgation before the parliament. So once the law comes in, probably there will be momentum towards people wanting to be trained as mediators, then registration of mediators, then quality. See, one thing is capacity building and the other is maintaining quality. So unless those standards are prescribed by some law, you cannot have quality, and therefore we need quality also. And that probably it will get fillip from the Mediation Act once it comes into force.
I just want to add that we need to try to encourage our universities. So, I mean, some of us try to support the universities. Right now, for example, the ICC runs an annual mediation moot for students. And we've tried for the last 5, during COVID, the moots were on ODR. But before COVID, we tried the law firms in Nigeria. We tried to support maybe 2 or 3 or 4 students each year to go from moots in Switzerland, in Geneva. The ICC, I think it holds in Switzerland every year, and just to encourage students. But of course, these things are very expensive. A lot of our students cannot afford. We also try, and then of course you have to consider getting visas. But just to show that there's something being done to encourage students is the is the mediation moot for students, which comes up, at least the ICC one I know about comes up once a year. And then we try to have small mediation and different arbitration moots within the country. So it's not that everybody has to be able to travel outside the country, but it's very important that we start early. So for the generation of those who are in university now, in the next 20 years, I don't think they'll be having this discussion as to convincing people to try mediation. Nobody ever taught us about it, except, I mean, when I paid to learn mediation, I laughed at myself and I said, this is interesting. I'm paying to learn mediation when I'm sure my great-grandfather sat down under a tree and mediated problems, mediated disputes for people in the community. But, everything has gone round. I always believe Africa has always had mediation. Our grandparents, our forebears, they sat down and they helped to resolve. And all these things, caucus meetings, they'll call you to one corner and talk to you. They'll call the other party to a corner and talk to you, bring you both together. I think we had these things before, but now, well, we have it on a different level. And for students, it must start now. Let's encourage them when we can afford it, maybe as the Law Society send them abroad to go for moots. It's just a 1 week or a 2 week thing, but it encourages them. They see that their mates in other parts of the world are doing it, and it helps them to get better. In fact, we now have mediation clubs at the secondary school level. That's the junior school level before they go to university. Also in Nigeria, just like I think Mr. Singh says, Advocate Singh says you have in India. So it's just starting as possible is the key.
Advocate Savio has a question. Since India has a 70% of population living in rural areas, is there a way to implement mediation at the panchayat level? And added to that, maybe advocates who wish to work as mediators can be appointed in the villages of our country. Mr. Singh.
Yes, as I said, ultimately, once a conflict becomes a dispute, parties come to lawyers. And when we talked about trust, they trust their lawyers more than mediator today in a court annex system whom they don't even know, till they have that choice to choose their own mediator. So once we have enough lawyers who have undergone the mediation training and are also very familiar with the local dialect and the language of that particular village. Once we have them, yes, these disputes which land up in court, even at that level of officials, as I said, panchayat level, they can be resolved. I don't see any reason why they can't be resolved. And most of the times you must realize, actually, most injurious experiences that I talked about of conflict do not become disputes because parties are really not aware of their rights. There is no, legal consciousness was the word that I used. They don't have that. And therefore, they don't actually land up in court because they don't know what their rights are, whether they have been infracted. And so that being so, a lot of disputes actually remain they don't land up in court at all. What we see are only disputes, which is tip of the iceberg. So once that empowerment happens, parties' right of self-determination, when parties understand what those disputes or issues are, or those legal consequences are, and lawyers are the best people who can guide them at that particular level. And it was rightly said that if lawyers are willing to take it up as a challenge, and that's why probably because since it's an established system, the legal system is established, and therefore it can reach to that level. So therefore, we don't have to have people going from Delhi, Bombay or Mumbai, or Chennai, Madras to actually reach that level. You will have people from districts and that level lawyers who are actually trained can go and do this process, conduct the mediation process very well, I'm sure efficiently.
Which is why Mr. D.K. Sami has a connected comment. He says, in India, also in the Panchayat Raj can include trained mediators, which is carrying your thought forward. Which is just carrying your thought forward.
Of course. You see, that's what I'm saying. Though Panchayat is not actually mediation.
Yes.
Because ultimately parties are heard, yes, the Panchayats take a call. So in that sense, it is not self-determination of parties. But yes, at that level, if they are trained, and trained mediators are included, I'm sure they will be in a better position to get those disputes resolved. And as I said, win-win situation for both the parties. Because once you understand what their real interests are, why they are in dispute or why they are in conflict, once they understand that. See, that's why the beauty of mediation is it transforms parties, even if it doesn't result in a solution or an agreement. The most beautiful part of mediation is, as I said, it's healing. When parties are in dispute, they need to be healed. And that this doesn't happen in courts. Courts will give you a judgment. Healing of conflicts doesn't happen in court.
Jayesh?
Yes. Panchayati Rajas that you have covered. Of course, training leaders of the villages as mediators is a very good thing, but there should be initiatives from the government system also. I feel that there are NGOs that were doing that. In fact, I know a couple of NGOs who are training the elected people of in the Panchayati Raj system, not the Panchs as such. Under the three-tier Panchayati Raj system, the elected members, they were trained, but I didn't find that it continued for a long, because there was no supportive system from the government. But it's a very good idea. I don't find much questions in the chat box now. I think if you allow, we can conclude it. What do you say, Prabha?
Yes, I would now request Jayesh to kindly give the closing remarks.
Yes. So it was a very energetic and very practical session, I will say, first of all. And both the speakers, Olusola and Mr. Singh, both of them started from the basics. Especially Olusola, I will start with her talk, that she started from the basics, and she took us through the system in her country and connected it with India by giving a fantastic quote of our Father of Nation, who we remember as the apostle of mediation and an example of a commercial lawyer transforming to a peacemaker. So we are so grateful and so thankful to you for remembering us about this great thing, and reassuring that all of us that mediation is worth a profession to take up, and mediation advocacy is a worthwhile thing to do. So we are so thankful and grateful to you for your lecture. On behalf of Nivaran, I express my gratitude for being with us and sharing your practical and your experienced thoughts. Thank you so much. JP Singh sir, your talk was really inspiring. Your talk was based on the Indian scenario and the practical difficulties that we face. Also, we discussed with you transforming from a litigating lawyer, from an adversarial lawyer to a person who can be an advocate for mediation and to inspire the people around. So you have taken that role, that very, I will say it's a very very responsible thing to say advocacy about mediation to litigating lawyers. It's not an easy task, because you will not get much support in the initial stages. People will say this is alarming drop in revenue. So we have to change it to an appropriate door for resolution. So I think you have done it very, very perfectly. And so we are very grateful to you by gracing this summer school. Your talk has added value, and your talk has given us a lot of confidence that we can carry this mantle. I also acknowledge the gracious presence of Mr. Brian Spears, Mr. Peter Marinard, both from the Commonwealth Law Association, President and Vice President, and Mr. Rene Baptist, President of the St. Winston Bar Association and the co-chair of the ADR Committee of Commonwealth Law Association, and our mediation guru from India, AJ Jawad. I find his presence also. And I'm grateful to all the participants who has added value to this discussion by asking very pertinent questions. So it was a really inspiring session and a very good addition to this summer school for Nivaran. Thank you. Thanks a lot.
Thank you.
Thank you very much. Thank you for inviting me.
Thank you, JP Singh.
Thank you, both
Shara.
of you.
Thank you so much.
Thank you.
Thank you.
Thank you so much.